So then we have a remark from Mr. Kasiswara Rao. He says that in Canara Bank versus Vantage Machine Tools, Section 7 application of the bank was not admitted for not adhering to MSMED framework for revival. So that's an information that he's sharing here.
So see, because of the Supreme Court judgment that we've just deliberated, the classification of NPA in this manner without adhering to RBI master directions is invalid ab initio. Like, although I'm saying that for Section 7, I don't need NPA classification. For Section 7, I just need a default. And the insolvency can even be initiated against any person for a default. Like, default can be even for a day. Classification of NPA is not a precondition for Section 7 application. I think what he's saying is maybe corrected to some extent, that this is not something which is the requirement of Section 7. And therefore, we need to see, maybe he's raising hand.
Kasiji, you can unmute and you say.
Yeah. Thank you for giving me opportunity. Actually, in that case, I think they have filed the Section 7 application after classifying the account as an NPA. Instead of
So they might have given the proof of default as NPA. I think that might be the problem there, and the NPA status must be disputed by the
borrower.
So that is then the bank here, which filed the Section 7 application, must not have given any other evidence for default other than the NPA status.
Yes.
I think that might be the differentiating factor.
Had the application been filed based on a default, which is the default of the terms and conditions of the loan sanction letter or the loan documents, then this NPA classification would not have actually been considered. But if the application is filed only because this account is NPA and the NPA classification is invalid ab initio, then Section 7 likely to be rejected.
Yeah. Thank you.
Thank you, sir. Thank you. Good morning, everyone, and welcome back to our weekly webinar series. At episode number 169 today, we are looking at the various judicial trends shaping SARFAESI and RBI master directions. Over to Anil, sir.
Thank you, Ankit. This episode, which is 169th episode of AAA weekly webinar series, is dedicated to the various judicial pronouncements which are relevant for asset reconstruction companies, either under SARFAESI law or under RBI master directions for ARCs. We have done 4 episodes focusing on asset reconstruction companies. First, we dealt with the relevant part of the SARFAESI law, SARFAESI Act, and then we conducted 2-3 episodes along with the experts in ARC segment, deliberating on RBI master directions on ARCs. We have been getting a lot of response, a lot of questions, and therefore this is the last episode for the series that we started for asset reconstruction companies. Today, our team could find some relevant judgments which are primarily on RBI master directions in some cases, or ARCs or SARFAESI, which are somehow relevant to asset reconstruction companies. And therefore, we can go ahead with this, and we in fact so we actually will start with something which is Supreme Court judgments, and the first judgment that we will start is from Honorable Supreme Court of India. This judgment is dated 1st August 2024 in the name of Messrs. Pronet and others versus Canara Bank, and this judgment was given by Honorable Justice Bela M. Trivedi, the same Honorable Judge who has given the judgment of Bhushan Power versus JSW steel. In this particular judgment, the importance of RBI master directions is kind of dealt with by the Honorable Supreme Court, not directly the master directions issued for ARCs, but this particular judgment dealt with the RBI master directions issued under Section 21 and 35 capital A of the Banking Regulation Act. And the Honorable Supreme Court has said that the directions have statutory force. The directions of RBI has statutory force. So therefore, before we go ahead, we will first see the kind of facts of this case. So in this case, the appellant, like including pronits, they were registered MSME under MSMED Act 2006. Their loan account was declared NPA by respondent banks, and they started the SARFAESI proceedings. However, the appellant, including Messrs. Pronit, they challenged the legality of such classification and enforcement, citing non-compliance with the RBI master directions and MSME notification dated 29th of May 2015, that is called Framework for Revival and Rehabilitation of MSME. This particular framework is the same framework which directs the banks that for MSME or even for other entities, you actually have to, first of all, dealt with the accounts progressively. First of all, it will be classified SMA 0, then SMA 1, and then SMA 2. So that is attracting the attention of the senior officials of the bank, so that there should be a separate discussions for SMA 0, SMA 1, and SMA 2 before the account is actually classified as NPA. Now, the Bombay High Court, in fact, in this case ruled that RBI or MSME instructions were directory and not mandatory. Thus, the banks were not bound to follow them suo motu. Therefore, the issue before Honorable Supreme Court was whether RBI master directions and MSME revival framework have statutory force and are binding on the banks. Also, whether SARFAESI proceedings are valid if MSME restructuring framework is not followed before NPA classification. Now, in this case, the argument which was done by the appellant, like the MSME segment, it was argued that in the notification dated 29th of May 2015 and the master direction, it is very clear to identify incipient stress via SMA categories, then initiate corrective action plan through committees, then give MSME a revival opportunity before classifying as NPA, and non-compliance renders SARFAESI actions void ab initio. That was the applicant. Respondent said that the SARFAESI overrides all inconsistent laws. Appellants had not applied for any relief under the framework. The framework is not binding, and proceedings under SARFAESI were duly completed. Now, the court, in fact, has held very clearly that the RBI master directions issued under Section 21 and 35A of the Banking Regulation Act have statutory force. Now, the relevant paragraph of the judgment, it is better that we should read for the benefit of our audience. The instructions for the framework for revival and rehabilitation of micro, small, and medium enterprises as notified by the central government void the notification dated 29th of May 2015 in exercise of powers conferred under Section 9 of MSMED Act as revised by RBI notification dated 17th March 2016 and the master directions, that is the Reserve Bank of India lending to micro, soft, and medium enterprise sector directions 2016 issued by Reserve Bank of India in exercise of the powers conferred by Section 21 and Section 35A of the Banking Regulation Act, having statutory force, are binding to all scheduled commercial banks licensed to operate in India by the Reserve Bank of India, such directions have got to be read as supplement to the provisions of the Banking Regulation Act, and accordingly are required to be construed as having statutory force and mandatory. So this is actually the relevant paragraph which says that the RBI guidelines are mandatory. So even the directions related to MSME revival are mandatory and binding on all scheduled commercial banks. So it is very clearly said that the framework which was notified by RBI for revival and rehabilitation of MSME contained in the instructions and directions of the RBI, that is binding on all the lenders. So therefore, identification of stress and classification under SMA 0, 1, 2 categories is compulsory before classifying MSME loan as NC as NPA. Enforcement under SARFAESI is permissible only after NPA classification, which must be preceded by compliance with MSME framework if borrower is a registered MSME. However, it is equally incumbent on MSME to produce verifiable document of their registration at an appropriate time. Since SARFAESI action had already been concluded, no retrospective reliefs were granted, but High Court's legal findings were overturned. And in case we see, the finding recorded by the High Court in the impugned order that the banks are not obliged to adopt the restructuring process on its own, or that the framework contained in the notification dated 29th of May 2015, as revised from time to time, could not be said to be mandatory in nature, are highly erroneous. The word used is highly erroneous and cannot be accepted. The instructions, directions issued by the central government under Section 9 of MSMED Act and RBI under Section 21 and 35 have statutory force and are binding on all banking companies. So the ratio decidendi directions issued by the RBI under Section 21 and 35A of the Banking Regulation Act are binding and not directionary. The MSME revival framework, although not part of SARFAESI, operates prior to NPA classification and must be adhered to the banking resolution. Now, question here is, in this judgment, what we are trying to relate is that RBI master guidelines are having statutory force. So therefore, the RBI master guidelines for ARCs also have the statutory force. So it is binding and it is not discretionary. That is the way this particular judgment is relevant. And when we move on to the another judgment, which is again from Honorable Supreme Court of India, and it is dated March 2023. This is the citation of this judgment is State Bank of India and others versus Rajesh Agarwal. And this was decided by erstwhile Chief Justice of India, Justice D.Y. Chandrachud. And in this particular case, the main issue which was involved, the main issue was whether the principle of natural justice, especially odi altrum partum, must be read into the master directions on frauds. Does the fraud classification process entails civil consequences, thereby warranting a pre-decisional hearing? No, although this judgment is on the master directions on frauds 2016, but in case there is anything which is entailing civil consequences, that actually should it have a pre-decisional hearing or not? Pre-decisional hearings or not, that is also important. Now, in this case, the background of this is that this appeal arose from challenges to RBI master directions on frauds, which was updated. It was 2016 master direction, which was updated till July 2017, particularly the various clause which permits the banks to, number one, conduct forensic audits. Number two, unilaterally classify borrowers' account as fraud. report to RBI, CBI, and debar such borrowers from access to institutions finance for 5 years. Now, the petitioners contended that this fraud classification process was conducted without any notice or hearing, violating the natural justice which is given in Article 19 of the Constitution. Now, the key facts of this case is there are multiple borrowers like BS Limited, Vimal Oil, Golden Jubilee. They were classified as a fraud based on the forensic audit. Borrowers were not provided with audit reports. They were not given any notice. They were not even given any personal hearing. The various writ petitions were filed, some before Telangana High Court, some before Gujarat High Court, and also the High Courts were giving mixed verdicts. So therefore, the appeal reached the Supreme Court of India for authoritative determination. So the issues before the Honorable Supreme Court, which was framed, one, whether the principles of natural justice, especially odi alteram partem, must be read into the master directions on fraud 2016. Second issue, does the fraud classification process entail civil consequences, thereby warranting a pre-decisional hearing? These are the two issues framed before the Honorable Court and the Supreme Court ruling. Supreme Court said master directions are administrative but binding. Even if it is administrative, yet it is binding. And it finally, paragraph number 32, in fact, reads as under. The process of forming an informed opinion under the master directions on frauds is administrative in nature. This has also been accepted too by RBI and Lender Bank in their written submission. It is now a settled principle of law that the rule of odi alteram partem applies to administrative action apart from judicial and quasi-judicial functions. It is also a settled position in administrative law that it is mandatory to provide for an opportunity of being heard when an administrative action results in civil consequences to a person or entity. Now, this judgment, although it is applicable to master directions on frauds, master directions on fraud is an administrative directions. But still, the Honorable Supreme Court said that let the other party say something. Let the other party also explain that legal rule is applicable to this master directions also. So what we are trying to conclude here is that the master directions issued by RBI for ARCs would also have this rule applicable. Now, what exactly the Supreme Court finally ruled, like the fraud classification has serious civil consequences. Classification leads to credit freeze, fatal for the borrower, akin to civil death. Debarring a borrower is akin to blacklisting. Opportunity of hearing is necessary. Natural justice must be read into directions. So the directions, whatever is directions of the RBI, the natural justice must be read. We hold, the Supreme Court said, we hold that the principles of natural justice, particularly the rule of odi alteram partem, has to be necessarily read into the master directions on frauds to save it from the vice of the arbitrariness. So to avoid arbitrariness, the rule odi alteram partem, which actually means let the other party have a say, let the other party also explain, let us hear the other party. That is what it says, odi alteram partem. In this particular case, what it says that these kind of natural justice provisions are applicable to master directions also. And the no implied exclusion by RBI. Further, the Honorable Supreme Court said, where the statute is silent, the court must presume natural justice is required, especially where rights are prejudicially affected. Now, in this particular case, the RBI directions on fraud has no provision where it is said that such assumption or exclusion of the natural justice is part of this master direction. No, there was no word written in this master directions that the natural justice is excluded. That was not there. So therefore, the ratio decidendi in this case is the Supreme Court firmly ruled that natural justice is not a procedural nicety, but a constitutional requirement. It is not something that we can say it is nice to be this way, but it is a constitutional requirement. When administrative actions like fraud classification is administrative, have the effect of debarment or reputational harm and criminal proceedings, the borrower must be given adequate hearing and disclose of material. This is what is there in this judgment. So, Ankit, I think it is time that you should also add your comments on these judgments that we've so far said, and or let us see if there are some questions. Yes.
I think these judgments are very important for one, the protection of MSME sector. And if RBI had directed that, okay, this is the way banks should work with MSMEs to make sure that they're supporting MSMEs in restructuring or supporting them in not allowing their loans to go bad, and the banks do not do that with full intention or with full commitment, then I believe that it will show up in the documents also. And I have seen a few MSME cases where the banks now make sure that this compliance is completed. Also, the banks increasingly are open to somebody coming in, talking to them. And one thing that I will share here is that one thing that somebody told us, and I think it sticks with me, that in case the banker, so this is something that private bank told us, that in case the management tells them that in case the officers believe that the promoter has nothing with him and the promoter is not trying to be smart or not trying to be clever, but he wants to settle something, then the banks are open to it. But wherever the promoters are asking for a discount and the promoters themselves are having a lavish lifestyle, there that bank says that no, you kind of make sure that you're not giving any discount to those people, and this is the perception in the market that they would want to build. So it's important to understand this thought process of banks. At the same time, the second this judgment that we talk about, where you kind of making somebody's life difficult by tagging, giving a tag to that person. So I think that needs to be with caution. We these days see that CIBIL, having a good CIBIL is such an important thing for people now to kind of have credit worthiness. Somebody who was an independent director in one business or in one company, and he might have signed some documents where he kind of got a status as a guarantor. That person struggles throughout life to have a business in his name. I recently came across somebody whose father used to own an MSME business about 20 years back. And he says, even after 20 years, I can't own anything in my name because I still have that outstanding guarantee sitting in my name. So I think insolvency, individual insolvency, corporate insolvency, I think all these are there to allow entrepreneurs in our country to start afresh. I think these are what it's important to understand that concept from these Supreme Court judgments.
I think based on these 2-3 judgments, there are some questions also. Intermittently, we should take some questions.
I have a question from Anil G. It just came up. So he says that the decision of Honorable Supreme Court is fine by making these guidelines binding, but the challenge is the time and the judicial system takes to follow the principles of natural justice. So speed is also important. So I think, yes, I agree that yes, judicial speed is something which is very important. We see that all the time. So I think there are two ways to go about it. One, to declutter those systems which require judicial interference. And also there is a process, or there is a logic that you streamline the judicial process or increase capacity. Two ways to
I would like to add in this answer, what you said is right. But to be more specific, what the courts are supposed to do whenever any application is filed or any appeal is filed, the court will first of all give this right of say to the other party. Now, if the other party raises some issues, then the right again comes back to the original applicant to file a rejoinder. In the rejoinder, if there are any new issues are raised by the applicant, which were not there originally in the application, then there is again a right is given to the respondents for a rejoinder. So this is which is called the right of say, right to let us hear the other party. No, unless the court hears both the parties, I don't think the natural justice can be given. So this is what the court said. Although it takes time because of the over occupation of our courts in India, but I think it is also not a good scenario that any person files an appeal or an application and action is taken. So this is mandatory for any justice across globe that both the parties must be heard to verify what the original person has said, to verify all the documents, and to accept or reject the documents submitted by them. So this is a process which is called legal proceedings. And once the pleadings are completed, then only the argument starts. So this actually is the time is taken only because of the adjournments and also because of the sometimes non-availability of the time with the courts. That is something which requires judicial reforms for increasing the capacity of the courts. Yes, Ankit.
We have Vipul G asking a question. He says, suppose a case is an NPA. So suppose a case of NPA on account of default on retail account and MSME account is regular. Then also such account needs to be sent to designated committee for revival and restructuring under RBI guidelines, or banks can go for SARFAESI action. So he says that the MSME account is regular, the MSME borrowing is regular, but the default is on account of a retail account. So do the MSME guidelines from RBI also apply to such cases where the default is on a retail account and not on the MSME account? I understand that if a retail account is under default, all the loan accounts with the bank will be declared NPA. You can correct me if I'm wrong.
No, if the retail, but I can understand the question in such
Let's say it's a car loan. Let's assume
yes, I'm saying that, first of all, I'm understanding in such manner that there are regular facilities, which is working capital and term loan for a project, for a business. Then there is a car loan or loan against property. So that is something which actually can be considered as a retail loan. So if there is a default, if there is a default in car loan or if there is a default in retail, then SMA 0, SMA 1 and SMA 2 is not applicable to SMA. See, for that part, for the MSME loan part, it is applicable, but for the retail loans, it is not applicable. Because this SMA 0, SMA 1, SMA 2, in fact, it is applicable now since the modification also came in 2017. In fact, it is applicable to all, but the MSMED Act is only applicable to MSME, because this judgment is a combination of RBI guidelines for this MSME framework and revival, and also this SMA 0, SMA 1, SMA 2, that is applicable to even non-SME units also, but not to retail.
So it will be then open to the bank to initiate the SARFAESI action for the retail default, and they won't be required to do any procedure under the MSME Act. I think you're accurate on that.
Yes. This is what I'm saying.
So then we have a remark from Mr. Visveswara Rao. He says that in Canara Bank versus Vantage Machine Tools, Section 7 application of the bank was not admitted for not adhering to MSMED framework for revival. So that's an information that he's sharing here.
So see, because of the Supreme Court judgment that we've just deliberated, the classification of NPA in this manner without adhering to RBI master directions is invalid ab initio. Although I'm saying that for Section 7, I don't need NPA classification. For Section 7, I just need a default. And the insolvency can even be initiated against any person for a default. Like default can be even for a day.
Yeah.
Classification of NPA is not a precondition for Section 7 application. I think what he's saying is maybe corrected to some extent, that this is not something which is the requirement of Section 7. And therefore, we need to see, maybe he's raising hand. Can we also see what exactly he want to say?
Kasiji, you can unmute and you say.
Yeah. Thank you for giving me opportunity. Actually, in that case, I think they have filed the Section 7 application after classifying the account as NPA. Instead of.
So they might have given the proof of default as NPA. I think that might be the problem there, and the NPA status must be disputed by the
borrower.
So that is so that the bank here, which filed the Section 7 application, must not have given any other evidence for default other than the NPA status.
Yes.
I think that might be the differentiating factor.
Had the application been filed based on a default, which is the default of the terms and conditions of the loan sanction letter or the loan documents, then this NPA classification would not have actually been considered. But if the application is filed only because this account is NPA and the NPA classification is invalid ab initio, then Section 7 likely to be rejected.
Yeah, thank you.
Thank you, sir. Thank you.
So, Ankit, any other?
Then we have a question from Priyanka Narang. Priyanka ji is saying whether MSME guidelines are applicable for NBFCs also or only for banks.
No, this process of classification is applicable to all. Process of classification into NPA is applicable to all. All
MSME,
regulated by RBI.
Yeah, MSME framework is also applicable to all. I think NBFCs are also supposed to require the restructuring process and all that.
Yes.
Applicable to everyone now.
Right.
Then we have a question which I can take up is I will take up the rest, and then I think if I have anything, I will put it up for everyone's benefit.
Okay, so we should move on to the other judgment then. Now, in this particular case, which is a case from Kolkata High Court, it is Hemant Kanoria versus Bank of India. This was delivered in February 2024, and in this case, the issue which was involved and the issues which were framed are show cause notices under the RBI master directions valid if they lack specific allegations against the individual director, do not provide access to supporting documents including forensic audit material? Does the fraud classification process under the RBI master directions require full compliance with principles of natural justice? So, although we are discussing something which is relevant to ARCs, but all these judgments are giving a kind of a ratio which is applicable to master directions of RBI. So therefore, we are discussing, because there may not be a judgment which is directly coming on the RBI's master directions on ARCs, but these are the master directions which are being challenged from RBI and various forums. So this is a judgment from Kolkata High Court, and similar judgment can even be found in from other forums also. Now, in this case, the petitioner is Hemant Kanoria, who was a director and promoter of Srei Infrastructure Finance Limited and Srei Equipment, both of which in fact faced insolvency and came under CIRP process in October 2021. A forensic audit was commissioned by the Joint Lender Forum, based on which the banks, Bank of India, Bank of Baroda, Union Bank of India, SIDBI, issued fraud classification show cause notices under RBI master directions on frauds 2016. So the petitioner was declared as fraud and perpetrator of fraud by Bank of India and Bank of Baroda in December 2024, and January 2024, respectively, without individual allegations in the original show cause notices. Now, the loan was taken by SRI Infrastructure Finance Limited and SRI Equipment Finance Limited. Both the companies were in CIRP. However, the master directions, RBI master directions on fraud 2016 was made applicable to Hemant Kanoria, who was the director of these two companies, and he was also declared as fraud and also perpetrator of fraud and by the banks. So his legal challenge before Kolkata High Court was the validity of fraud declaration under the RBI Master Directions on Fraud, where the citing lacks of. There was no personal allegation against Hemant Kothari, or I can say director of the company. There was no access which was given to the director or to the company on various documents relied upon by the bank. Sufficient time to respond was not given, and the compliance with the procedures laid down by Supreme Court in the case of Rajesh Agrawal, which is a 2023 judgment, we might even discuss that later. That particular judgment was also referred, and before the court was, are show cause notices under RBI master directions valid if lack specific allegations against the individual director? So basically what is trying to say that if individual allegations are not there, then can that individual be declared as fraud? Then second is, do not provide access to the supporting documents, which is the forensic audit and other materials relied. Does the fraud classification process under RBI master direction require full compliance with the principles of natural justice? So though we are now trying to say the principles of natural justice. One, that the other party must have a say. Let us hear the other party. Second, the documents which are relied by us, the other party also must have those documents. In case those documents are not given to the other party, the declaration of fraud cannot be considered as compliant to natural justice principle. Then the court actually found in this case that in fact I'm reading verbatim, and although the process of fraud declaration is summary under the master directions, the principles of natural justice have to be read into it as much as possible, since such principles are the basic features of rule of law and cannot be short shrifted. Now, on the nature of the master directions, again the court says, actually reading verbatim, the purpose of the master directions is to detect and report frauds early and enable the banking system to take preventive steps, but it does not amount to criminal conviction. Then on the contents of show cause notices, even if no specific allegation is leveled against the petitioner being a director, implicit in the allegations against the company is an allegation against the persons managing it. So this way, even if there is no personal allegation to a director, but whatever allegations are made against the company, that also somehow implicit, those are implicit to the persons who are managing it. Then the RBI master direction must balance speed with fairness. A structured opportunity of hearing, including access to key documents, timeline for the reply, and reasoned decisions must be followed. So these were finally the final decision of the court. In fact, was the fraud declaration by Bank of India and Bank of Baroda against the petitioner set aside. Banks directed to provide relevant forensic audit documents, allow inspection or furnish copies, grant additional time to reply, conduct a reasoned hearing before taking any final decision. The decisions declaring the petitioner as fraud or perpetrator of fraud by Bank of India and Bank of Baroda are hereby set aside. SIDBI was directed to serve audit reports before continuing with show cause notices. And this is, let us understand what is a ratio decidendi. Even in the summary regime like RBI master directions on fraud, natural justice principles must be incorporated, including notice with particulars, disclosure of material relied upon, for example, audit report, reasonable opportunity to respond, speaking and reasoned order, final orders. So this is what is the judgment, which is again focused on natural justice, other parties have a reasonable time, other parties to have access to all the documents relied upon. So this is from Kolkata, and that is based upon, that judgment is based upon the judgment of, that is judgment of Supreme Court in the case of Rajesh Agarwal and State Bank of India. Then we actually can move to the other judgment, which is from Delhi High Court. It is in the case of Sanjay Tikku versus Reserve Bank of India. Sanjay Tikku versus Reserve Bank of India. And in this particular case, the petitioners, which are former directors of JMT Auto Limited, challenged the classification of the company's bank account as fraud. Again, the same judgment, similar judgment, and we can only say it is also based on that judgment, which is State Bank of India versus Rajesh Agarwal from Supreme Court. And again, the same discussion and the same actually, the Supreme Court has again categorically held that the principles of natural justice, particularly the rule of odi alteram partem, has to be applicable and has to be necessarily read with the master directions. So any master directions issued by RBI definitely will have to just add the principles of natural justice, and also they should have the access to the other documents. That is something which is a must. The serving of notices, giving them proper time, and that is what is applicable in this case also. So this is something that we were focusing on, the natural justice principle, which is applicable to master directions, applicable to ARCs also in case of such disputes. Now, the issue which is again important is, which is actually resolved by NCL80. It was dissolved by NCL80, the principal bench, and from the court of the chairman of the NCL80. It is in the case of Alchemist Asset Reconstruction Company Limited versus ASC Insolvency Services LLP. Now, in this case, the issue was the RBI Master Directions 2024, RBI Master Directions 2024 for asset reconstruction companies do not prohibit ARCs from assigning debts to non-ARCs. The directions allow ARC to adopt various asset realization strategies, including settlement of dues and assignment, provided the plan aligns this with COC approved resolution strategies. The assignment of unsustainable debt to the SRA was part of a resolution plan approved by the COC in accordance with the IBC and thus permissible. This judgment is as recent as 15th of May 2025. In this case, the CIRP of Helio Photovoltaic Limited was initiated on an application by NARCL, that is the bad bank commonly known as. The COC comprised like 3 members, NARCL, Alchemist, and IFC. And after the challenge process, OCL Iron and Steel Limited was declared successful resolution applicant, and the plan received 73.38% approval. Alchemist, the dissenting creditor, filed the present application challenging the approval of the plan by NCLT on the following grounds. However, we will restrict our discussion to something which is applicable to ARCs, that is, that the assignment of unsustainable debt to a non-ARC entity was in violation of SARFAESI Act and the RBI directions. This is the only thing that we are going to deal with in this. So the issue which was framed, which is relevant to ARC, is whether the assignment of debt by an ARC to a non-ARC is contrary to the SARFAESI Act and the RBI Asset Reconstruction Companies Direction 2024. And in this case, the tribunal, in fact, observation of the tribunal was, the tribunal held that the RBI Master Directions 2024 for ARCs do not prohibit ARCs from assigning debt to a non-ARCs. The directions allow ARCs to adopt various asset realization strategies, including settlement of dues and assignment, provided the plan aligns with the COC approved resolution strategies. The assignment of unsustainable debt to successful resolution applicant was part of a resolution plan approved by the Committee of Creditors in accordance with the IBC and thus permissible. Then the decision was that the appeal was dismissed. NCL 80 upheld the commercial wisdom of the COC and affirmed that the resolution plan was neither in violation of SARFAESI Act nor the RBI directions. And therefore, the ratio decidendi in this case is assignment of debt by an ARC to a non-ARC under a duly approved resolution plan is not barred under SARFAESI Act or RBI Master Directions 2024. So this is what once the plan is approved by the COC with requisite majority, the scope for judicial interference is limited, particularly when the challenge is premised on commercial assessment or process deviation not amounting to legal infirmity. So the challenge was the commercial assessment, the challenge was on the process deviation. So therefore, it was not amounting to legal infirmity. So this is also important. Now, when we see the master directions, I can only say that the master directions are, in fact, in case we see this master directions paragraph 58 of RBI, although it is applicable. Now, what it says, paragraph 58, it says, notwithstanding the stipulations in clauses 54, 57, if transfer of stressed loans are undertaken as a resolution plan, but this resolution plan is under the Reserve Bank of India Prudential Framework for Resolution of Stressed Asset Direction 2019, results in an exit of all lenders specified as class 3 from the stressed loan exposure, such transfer, now transfer and assignment is same, such transfer is permitted to any class of entities. So this is the RBI master directions on ARCs. It is applicable to RBI Prudential Framework for Resolution of Stressed Assets Direction in 2019, but the court, the NCL 80, has finally held that in this entire master directions, it is not said that it is not applicable to a resolution plan under IBC. So therefore, the assignment of debt in a resolution plan by an ARC to a non-ARC has been upheld by NCLAT, and that too from Chairman's Court. Ankit, this is very important, and I hope my PPT is okay, or should I?
Sir, PPT is not visible right now.
Okay, let me see. I will stop sharing and then again I'll come back. In the meantime, Ankit, we can actually take some questions in case there are.
No questions that I can see in the Q&A box. Any of the participants who would want to ask a question, they can raise their hands. They can raise their hand and I can take up their question. So I have Mr. Mehraj Kumar. You may unmute yourself, sir.
Yes, sir. Am I audible?
You're audible.
Very good afternoon. Actually, I have one query regarding, you said that applicability of this SARFAESI is not extended to unsecured business loan?
Yes, it is not.
Okay.
Applicability of SARFAESI law is not on unsecured business loan.
SARFAESI has many components. The enforcement of security provisions will not be applicable since the security is absent. But yes, the first part where you talk about securitization, that can happen under SARFAESI even for an unsecured loan.
No, we were discussing about the card loan a little while ago.
Mm-hmm.
So can the director be?
In car loan, and the SARFAESI law is also applicable, and the Motor Vehicle Act is also applicable. So most of the banks are going as per the procedure laid down in Motor Vehicle Act. and less of the banks are going through the procedure of the enforcement of security interest as per SARFAESI law.
Suppose the bank extends the loan without having a mortgage of that car, then in that case?
No,
Without hypothecation, there is normally that's not a practice at all. Even if you say that, okay, the banks have given a loan without the hypothecation of the car, then it will not be an unsecured loan. The registration of under the Motor Vehicle Act will not carry the hypothecation. So it will be an unsecured loan. Today, I can give you an unsecured loan and say that, okay, you can use it to purchase a car. That's always possible.
Yes.
But then there's no enforcement under Motor Vehicle Act or SARFAESI Act in that case. For Motor Vehicle Act, the RC, the registration document, has to have the hypothecation recorded.
Great, sir. Thank you so much.
So moving forward, we actually can now move to
we have another question. We can.
Yes, please.
So I'm not able to understand the name from the email address, but I have. You can unmute. I think Vijaya. That's what I can see.
Hyderabad.
Yes, if you would want to unmute yourself.
Sir, can you hear me?
Yes, please. We can hear you now.
Sir, my doubt is that some accounts are being assigned to ARCs where the NBFCs are not having SARFAESI power. But these accounts, when they get transferred to ARCs, now the ARCs have permission to do SARFAESIs. So is it allowed now?
No, I think like in case the original loan which was given by the NBFC and that particular NBFC was not compliant for SARFAESI actions, and if it is again assigned to an ARC, I think the NBFC powers will also go. All the powers with NBFC will go along with the assignment or along with the transfer of debt. I
think SARFAESI should be available to the ARCs.
No, we need to see judgment because I still have not seen any judgment which says that the non-SARFAESI NBFC can transfer to ARC and then SARFAESI would be applicable. It is not possible. In that manner, all the NPAs of non-SARFAESI NBFCs will get transferred to ARCs. So this is not permitted. Any NBFC which doesn't have the power to enforce as per SARFAESI law, if they assign to ARC, the ARC's power will also be restricted. ARC will also not have the power to enforce.
We can check if anyone has seen such cases, but technically, I don't know aware of any bar there. But that's just market dynamics then, that some NBFCs who do not have the power to exercise SARFAESI will have to sell assets to ARCs to realize or to make SARFAESI possible.
No, but that's not legal. That's not legal. I will share the judgment after this webinar. We'll spend some time and I will share the judgment. Is that all?
Yes.
So I think now this is one important.
We have some comments here that DRTs have held that it is not permissible.
Yes, so it is not permissible. So we have another judgment which is important for all the ARCs to understand, that is Bank of India versus Sri Nangli Rice Mills Private Limited, and this judgment is as latest as 23rd of May 2015, and it is from Honorable Supreme Court. No, this actually says that the Section 11 of the SARFAESI Act. Section 7 of the SARFAESI Act says where any dispute relating to securitization or reconstruction or non-payment of any amount due, including interest, arises amongst any of the parties, namely the bank or financial institution or ARC or qualified buyer. Such dispute shall be settled by conciliation or arbitration as provided in the Arbitration and Conciliation Act 1996, as if the parties to the dispute have consented in writing for determination of such dispute by conciliation and arbitration and the provisions of that act shall apply accordingly. Now, this section 11 is now called as a statutory arbitration. This particular section 11 of SARFAESI says that even if none of the document says that the resolution of disputes will be through arbitration law, but this section 11 mandates that if there is any kind of dispute, and that dispute is between four stakeholders: one, the bank, financial institutions, ARC, or a qualified buyer, and this dispute will be settled through arbitration. That is something which is in this particular judgment. The background that I'll have to give is the Bank of India had granted working capital loans to Sri Nangli rice mills by a hypothecation of stock over rice and paddy stored in NBHC godowns. A credit facility was extended in 2006, explicitly prohibited the borrower from creating any third-party interest in the hypothecated goods. And then in the breach of this clause, the borrower obtained further facilities from Punjab National Bank in 2013 and pledged the same stock. This led to a competing claims over the same goods by both Bank of India and PNB. The district magistrates on PNB's application under Section 14 of the SARFAESI Act ordered protection of the stock, and the Bank of India initiated proceedings before DRT seeking relief, which culminated in an order for joint sale of stocks. Now, this order of DRT for joint sale of stock, because both the banks have a document creating charge on the stocks. The matter actually reached out to DRAT and thereafter to Delhi High Court, both of which directed that the dispute be resolved through statutory arbitration under Section 11 of the SARFAESI Act. Bank of India, not happy with this judgment of Delhi High Court, appealed to the Supreme Court, contesting the jurisdictional competence of statutory arbitration and claiming the DRT retains the jurisdiction, so the DRT should do it. Now, in this case, the issue for consideration before Honorable Supreme Court was whether Section 11 of the SARFAESI Act is a mandatory statutory arbitration provision applicable to interstate disputes between the secured creditors, including disputes over priority. Whether DRT have jurisdiction under Section 7 to adjudicate disputes between two banks or financial institutions involving the same secured assets, whether ARCs or as a secured creditor are entitled to invoke statutory arbitration under Section 11, whether exclusion under Section 31, subsection B of the SARFAESI Act bars arbitration of disputes involving pledge of goods. So, one, it is very clear that the SARFAESI law is not applicable to pledge. What I understand, when the stock is pledged through NHB and NBHC godowns. So that actually, although the word used here is hypothecation, but I believe it should be pledge. But in case it is a pledge agreement, then SARFAESI law is not applicable. It is very clearly written in Section 31 that the particular law is not applicable. The SARFAESI law is not applicable to the pledge transactions. And in this case, the mandatory nature of Section 11 is also very clear. The court held that Section 11 is standalone statutory arbitration mechanism enacted to govern disputes amongst the banks, ARCs, and qualified buyers and FIs. It operates independent of any private arbitration agreement. It operates independent of any private arbitration agreement, and once invoked, ousts the jurisdiction of DRT and civil courts in such manner. The use of the word shall makes invocation of arbitration compulsory and not discretionary. Now, there is no conflict with Section 31, subsection B. Section 31, subsection B excludes disputes relating to the pledge enforcement between borrower and secured creditor. It does not apply to disputes between two creditors such as banks or ARCs. So that is only between the borrower and the secured. The court clarified that the nature of the parties and dispute, not the form of security, determines the applicability of Section 7. Therefore, it is very clear that the expressly recognized ARCs as statutory parties covered under Section 11 entitles to invoke arbitration for disputes relating to securitization transaction, reconstruction arrangement, non-payment of dispute, priority disputes and over the other secured creditors. The court relied on the DRAT decisions such as CFM Asset Reconstruction Companies versus Tamil Nadu Mercantile Bank Limited, where an ARC dispute with a bank over priority and security rights was directed to be resolved under Section 11. The approach was affirmed by Supreme Court in this present case. So basically, the DRAT, what was held by DRAT in CFM Asset Reconstruction Company versus Tamil Nadu, that was also affirmed by the Supreme Court in this case. The court, Honorable Court, further clarified that the ARC need not enter into a separate arbitration agreement. Statutory entitlement under Section 11 suffices. DRT lacks jurisdiction in such disputes where both parties are institutions covered under Section 11, even where a secured asset is under pledge or hypothecation. Interstate disputes between an ARC and a bank are arbitrable under Section 11. Now, the decision of the Supreme Court in this case was the appeal was dismissed, and it was the view taken by DRAT and Delhi High Court was upheld. So this is what is, Ankit, in this case that we have with us. I think in case the time is up, or should we so the other law that we wanted to say that like GBJ Hotels versus Shri Haran Shripath Manathan. So this is a case where in fact the Supreme Court actually has held, I will just go to the conclusion. The Supreme Court has held in a case that in exceptional circumstances where a significantly higher bid is received after conclusion of an auction under SARFAESI, the court may, in exercise of its equitable and inherent power, permit consideration of such bid to maximize realization for secured creditor, provided the sanctity of the auction process is not undermined without cause. However, such orders are fact-specific and cannot be treated as a precedent. Now, in this case, the first offer which was there in the first offer which was on the auction, the auction in the auction in fact achieved rupees 108 crore, and GBJ Hotel was offering 108 crore, which was accepted, and then before finalization, Madras in the GRT Hotel in fact offered 120 crore. And the Supreme Court, in fact, said that both the parties should give a revised bids. So in the revised bid, in fact, GRT Hotel gave a bid of 153 crore. So therefore, the court said, since the difference is too much as an individual case, which is not to be treated as precedent, it can be said that for the maximization of the realization, the court, in fact, has used its powers. However, this cannot be considered as a precedent because otherwise it will be kind of diluting the sanctity of auctions under SARFAESI law. That's what it is. And then again, one thing is very important, that a writ petition in this judgment, the Honorable Supreme Court has held in this case of Phoenix ARC Private Limited versus Vishwa Bharati Vidya Mandir. It is said that the basic issue is that whether a writ petition under Article 226 of the Constitution of India is maintainable against a private ARC taking action under the SARFAESI Act. Now, the Honorable Supreme Court has said that the Section 226 it held that writ not maintainable. The Supreme Court held that a writ petition under Article 226 is not maintainable against a private financial institution or ARC as Phoenix ARC, particularly for proposed actions under Section 13, subsection 4 of the SARFAESI. So the alternate remedy is available only under Section 7 for filing an appeal before DRT. So this is what is important, that the writ cannot be filed against a private ARC. So this is what, Ankit, in fact, we have some more like kind of judgment, but then the time is up, so we actually have to conclude it. And this also, this also concludes our a kind of series of episodes on asset reconstruction companies. In case we are preparing a complete series on NBFC. In case it takes time, I think in between we will have a episode on latest Supreme Court and NCLAT judgments, and after that we will start the series on NBFCs and various law and master directions on NBFCs. Yes, Ankit.
So thank you so much, everyone, for participating in today's discussion. And it was a very good session that we had. A lot of things that I think legal concepts and good judgments that we discussed from the Honorable Supreme Court. Thank you so much, everyone, for joining in. And always a pleasure to spend this 1 hour every Saturday learning with everyone.
It is our way of learning. Thank you.
Thank you. Thank you, everyone.